Oasis Forum, which is a consortium of church and civil society organizations, were hosted at State House to a meeting with the President to talk about Bill number 7, its content and way forward. It was resolved at that meeting of 30th November 2025 between the government of the Republic of Zambia, the executive led by President Hakainde Hichilema, and the Oasis Forum, whose delegation leader was the NGOCC, I think CEO or chairperson, Madam Beauty Katebe, that a small working group was to be constituted to look at how to move on in terms of Bill 7 with a possibility of having a convergence of minds or consensus. The following day, 1st December 2025, the selected small working group began its work in earnest, with government represented by, with a team led by Attorney General Muliro Kabesha as the chief legal advisor to cabinet, who went into this small working group meeting with the Oasis Forum. And at that meeting, the Oasis Forum produced a document dated 29th November 2025, whose content was to the effect that there was no dialogue required about Bill 7. It had to be withdrawn completely, and that is to say that was their position and no other.
I wanted to just contextualize the dialogue.
Yeah.
In a dialogue, I mean, I'm a lawyer, and I know you go in a dialogue in a give and take, with a give and take stance. Yeah. Why? You want a dialogue to really result in something tangible, something that will progress the discussion going forward. Mm-hmm. But what the dialogue cannot achieve is to nullify legal standards that are placed in the law. It's not within our powers as Oasis Forum of its introduction on the floor of the House. It must be gazetted. We go to a dialogue table and say, no, let's get rid of that. It's beyond us. We can't go to a dialogue table and say, the law says, look, not less than 2/3 of the members of the National Assembly must approve this bill before it can go ahead. We go on a dialogue table as a Oasis Forum and government and agree, look, the bill is so nice. The terms, delimitation is such a good thing. I think let's get rid of this 2/3 requirement. All the other requirements, which are also in Mukandila case, are the same legal standards. So we can't go on a dialogue table and say, look, the law expects that the framing of the amendments must come from the people. We go on a dialogue table as a Oasis Forum and say, no, even if the law says that, I think let's just take the ones you have proposed, even if they didn't come from the people, and deal with their merits. It is not our call. It is a constitutional safeguard that the law has placed on. Yes, so what we're saying is the Constitutional Court has been categorical, very clear and unambiguous. What they are saying is this process must be driven by a technical committee. But having a technical committee alone is not a compliance of the judgment. Okay. So have a technical committee, one. You are on the right track. Stage number 2, go to framing the amendments to be made to the Constitution. Don't give the committee to consult the people on amendments that come only from the government, because you are gagging the owners of the Constitution. They may have more pressing issues. So the committee's first job is to frame the amendments. 1, 2, 3, 4, 5, consulting the people. What do you think can be amended? Only after they have been framed and put as proposals do you go to the people as the committee did.
Right.
Government is saying merely having a committee and consulting without involving the people in the framing of the amendments is compliance. That's not something we can negotiate.
What are the